My name is Connor Zapponi. I am the Operation Manager of ECHO, otherwise known as the Educational Council of Homeowners. Thank you for participating in this community conversation, discrimination, and reasonable accommodation. ECHO is a statewide nonprofit association established to support HOA board members and engaged homeowners. Our mission is to foster a better quality of life in community association through education, advocacy, and connections. For today's event, we have a few housekeeping items. These are presented on the screen now. In addition, slides were sent to registered attendees prior to today's webinar. Please take a moment to review our housekeeping items. The chat icon is to be used to report technical issues and to communicate directly with other participants in the webinar or the speakers or myself. You can place your questions in the Q&A feature. I will try to answer some questions during the presentation, but we may answer all questions during the Q&A portion at the end of today's webinar. Questions about specific situations are better asked of the attorney serving your association or another appropriate industry professional familiar with your specific situation. Now let me direct your attention to the monitor where you will find our disclaimer. None of what is said during this seminar shall be construed as specific legal or expert advice from the speaker, sponsors, or ECHO. If you wish specific advice, we encourage you to contact your attorney or another suitable expert. The information we provide during this webinar is educational in nature and should not be relied upon for specific decision-making purposes. Thank you. This event, as well as all our events, are made possible by the contributions of our generous professional sponsors. Today's sponsors we have, for our Q&A session, CID Consortium, LLC, and our registration sponsor for today's webinar is Levy Erlinger and Company, LLP, CPAs. We want to say thank you to our professional sponsors for making these possible. Now a little bit about today's speaker. Mark Guthies Esquire is the founder of Community Legal Advisors Incorporated, which represents more than 500 HOA communities. His firm provides assessment collections and general counsel services. For more than 20 years, Mark has provided general counsel and civil litigation services to the firm's community association's client. Mark also serves as a member of the ECHO Board of Directors. So now I'm going to say thank you, Mark, and hand it off to you to begin today's program.
Thank you very much, Connor. Always a pleasure to work with you. It's great to be here, and I'm very thankful for this opportunity. By way of disclosure, I woke up sick this morning, and so you may hear some horrific coughing, in which case I'll try my best to get to the mute button as quick as I can. Yes, we have a new pope. That's very exciting for us Catholics, and so that's an exciting day. And it's also strange because we've never had an American pope before. Born and raised in Chicago. That's kind of a neat thing. All right, so let's get to a community conversation about discrimination and reasonable accommodations. And the first thing that I want to do is flip the thank you. Perfect. That's what I want to say. Look, I am going to teach you what you need to do in order to avoid prosecution for fair housing, discrimination at your community. But I'm not teaching you that so that you can be discriminatory. I'm teaching you that because it's very expensive. This is a government entity which is funded by the taxpayers to sue your association. So they have unlimited money. And when they do, it's usually anywhere from $5,000 to $110,000 experience to defend associations. And there's not always insurance available, because sometimes the insurance takes the position that discrimination is an intentional act, right? And so there can't be insurance for it. So the first thing I want to lead with is discrimination is not acceptable, not at any time, not in any manner. These people are hurting, and for every one that is obviously trying to use the law to skirt their obligations or to get a better parking place or something, There's 10 who legitimately need our help as the community. And I think this is a great way where the community. The example I'll give you is this. I was working with an association. They had kind of a unique design. It's just outside of the La Costa Resort. And as you walk into this association, it's a building. It's a building. As you walk into this building, you walk down a courtyard, into a courtyard, and then up steps into the front entry. This is kind of an Eastern American design, East Coast design, and it's very impressive, but it's a lot of steps, unnecessary steps. And somebody came in, owners came in and said, "Look, I want to build a ramp." And to everybody in the room, it looked an awful lot like a skateboard ramp. It looked like a really terrible thing. Uh, and the board of directors kind of looked at it and kind of convocated, I guess, and said, "Hey, we're all getting to the age where we're not going to be able to climb these steps. Let's look at a more holistic solution than what you're proposing, this wooden skateboard ramp." And they matched. The owner was going to spend about $10,000 on the ramp. The association came in and spent another 50. And together they built a very architecturally pleasing ramp into the entry of the building. And this is sort of the nature of my conversation with you. So as I talk about recognizing it and how to avoid a claim, I'm not saying that it's okay to try to shirk your responsibility as a leader in your community. Let's go to the next slide. I think I've killed that idea, Connor. The first thing to know is people who misbehave, people who actively, act with discrimination, they think they're under the illusion that we're going to have to come back and prove it. And that is just not the case. It is true that the entity, the Department of Fair Housing, and so how these claims go down is this. Somebody feels discriminated against, they write a letter to the association, nothing happens, right? And then they go online. And when you go online, you can go to fairhousing.org, and if you go to the federal website, it just forwards you back to California if you lived in California. And if you live in California, or if you go to the California website, you're already there. And at that point, if you can convince them that you've been done wrong, the entire legislative or legal, not legislative, but legal power of the state of California comes in to sue. And so this person thinks, oh, well, they're going to have to prove that I did something wrong. And the answer is, well, you're actually going to have to prove yourself innocent. And yeah, it's a burden of proof where they have to prove you're guilty, but you're going to spend a lot of money. You're going to spend a lot of money defending yourself and proving that you're innocent. So it's not people can't misbehave and go, well, you have to prove that I said it. The answer is, well, yeah, but you're going to spend a lot of money defending it. The first thing I want you to do is recognize a potential claim as a leader within your community. What does that claim look like? And I'll tell you, it looks like passion. If you, first cough of the day here. If you receive a 5-page letter from somebody or a 3-page letter, and at the end it says, and I believe this is because I consider myself a homosexual man, or I think this has done this because I'm a woman, or I think this occurred because I'm black or purple or yellow, that is a big red flag. All right. So more subtly, what you have to look for is a situation where somebody enters the room and says, "Hey, I was wronged here." And you've got to realize that the people that are protected by the Department of Fair Housing are everybody but maybe me as a white male. If you're a woman, there can be disparate treatment between you and a man. If you are any one of the protected class, race, color, creed, sexual origin, sex, all of these things are protected people. And so your job as a director is when something comes in, and there's a conflict of owners, you have to look and say, is this something that's sort of charged with race, color, creed, sexuality, national origin, or something? So in the old days, we used to say on the boards, oh, that's a neighbor to neighbor dispute. There's nothing we can do about it. I have to tell you that under fair housing laws, there is no more neighbor to neighbor disputes. They are disputes which the association needs to address. And I will acknowledge up front that that sounds a little daunting, but I will help you recognize the courts have been really balanced about it, and I think fair. So we're going to talk about those decisions. So you need to recognize the claim. Now, here is where the Department of Fair Housing is a one-trick pony. And this is how you avoid the claim. This is your strategy to avoid claims. The thing that the Department of Fair Housing prosecutes and successfully prosecutes on is failure to respond. You almost can't respond wrong. Oh, I'm sure you could, but it's failure to respond. So what happens is you get the letter, you don't do anything for 6 months, and then the person claims to the Department of Fair Housing. Department of Fair Housing comes back and looks and says, how did you handle that 6 months ago? So the answer is hold an immediate hearing. That's the trick. When somebody comes in and gives you a letter or complains to the board that they're being harassed, have an immediate hearing with them. Have it, 2 days later with a majority of the board, or if their complaint is with the board member, ask that board member to sit out, and then go back and have a hearing with the board member, or have a hearing with the other member, the wrongdoing member, if you will. And then the board can make a decision. Is this really something that we can do something about, we should be doing something about, or is this really an invalid claim? And your attorney should be brought in and will help you make that determination. But the key is the immediate response. Don't sit on this. Hold an immediate hearing. If you do that, you almost avoid prosecution most of the time. All right. The other thing is I want to introduce to you is this is about giving due process to people. We don't need necessarily to decide that neighbor Jones is a bad guy and that neighbor Jones needs to be punished with blah, blah. But we do need to go through the process of holding a hearing with each of the parties. And then we need to kind of talk about what's going on at those hearings. So I want to introduce you to the idea that in that immediate response, we don't have to penalize or fine somebody. We just need to sit down and listen. And there's a lot gained by listening. Let's go to the next slide. Yes, okay. So Revcock Bay is kind of an interesting case because it begins to show the full panoply of who can bring a claim, who can be sued, and the court's activism in terms of making sure that that action is taken. So Revcock versus Cowpet Bay. If you have a minute while I'm talking, go ahead and Google Cowpet Bay. It is a gorgeous bay in the American Virgin Islands, and this is very nice stuff. And these people live in, I think it's one of two condominium buildings that overlook Cowpet Bay. And so Revcock moves in. Now it's either a lesbian couple or it's a brother and sister, husband and wife. It's I don't think it's a husband and wife. I think it's kind of an alternate couple. But in that situation, they move in with their dogs. Okay, so this takes some explanation. In the state of California, we used to be able to preclude dogs. There was a case, Lambden, not Lambden. There's a case Narstadt where the court said if the CCNRs say no dogs, you can't have a dog. And then, since then, the loser of NARSTAT approached PETA, and PETA got legislation passed that says you can have one dog in California, even when the CCNRs say that you cannot. Okay, so it is still the law in Calpet Bay. It is still the law in the American Virgin Islands that CCNRs can preclude pets. The Revcocks showed up with pets. Well, I should say they showed up with prescriptions. They showed up with two dogs, both of which had not training as such, but both of which were recognized as handicap assisting dogs, emotional handicap. So Revcox sue. So what happens is they move in the association. Suddenly, in the association's intranet, there's discussions back and forth with board members, between members, and all sorts of things about the Revcocks and how they have these dogs. And the Revcocks finally make a statement, probably too late in the process, but along the process, and say these aren't dogs, these are prescriptions, and we need them for our handicap purposes. And so so the conversation, and so we expect the conversation to stop now because we're talking about our own need for prescriptions. And so the Revcocks sue. And this lawsuit goes on for 5 or 6 years, during which the Revcocks pass away. Okay, who did they sue? They sued the owners. They sued tenants who discussed things on the website after they said, we expect no further conversation about this. They sued guests who came in and made statements. They sued employees. They sued vendors to the association who had made statements. And they used the Department of Fair Housing to do it. So it was free for them to cause this havoc. And the nature of the lawsuit was Calpet Bay went in for an injunction and said, hey, we shouldn't need to prosecute the lawsuit anymore because the Revcocks died. And the court came back and said, oh no, the wrongdoing occurred in their life, and we intend to penalize the wrongdoers for violating this federal statute. And that should cause chills to all of you listening. That's a pretty damning decision, right? And so we need to understand that, when you've got what I call the manager in a box, you've got 3 or 4 elevators that go down to a first floor where the manager is, and people are going down to that first floor going, oh, fuck you, the manager, and stuff like that. That's a uncomfortable, whatever the term is, work environment. You're placing these people in a horrible work environment, and that's a legal action. Those people can sue, maybe not necessarily based on fair housing, but certainly based on California employment law. So we all have those associations. A little coffee, we'll keep going. So just be aware of how these claims can come about. Next slide. Connor, you're doing a great job. What discrimination laws? There's a series of laws that arise out of trying to accommodate the handicap. So we have ADA when we're going into a public location, a restaurant, church, store, that kind of stuff. We have a public accommodation. With the Federal Fair Housing Act, this is what people generally access, the federal fair housing. But in California, we also have the Fair Housing Act, as opposed to the Federal Fair Housing Act. The Unruh Act, and that is found at Civil Code Section 51. Basically, in the case of O'Connor versus Village Green, the association precluded children within the association. And What they said was there's going to be pools for adults and there's going to be pools for children. And so we're going to exclude children in these pools. And the court said, no, you're not. Separate but equal is inherently unequal, kind of a Plessy versus Ferguson argument. And so the Unruh Act is valid and active in California. And then local building codes, and how this manifests is you'll have situations where commercial tenants are building improvements, and because of that, they have to improve their to the public street access for handicapped people. Local building codes also affect you in homeowners associations when you go to improve your clubhouse and you're spending $100,000 on the clubhouse, and the city or county comes back and says, well, if you're spending $100,000 on your clubhouse, you need to spend at least $15,000 of it bringing your bringing your bathrooms up to handicap status. So there are a series of laws that help our handicapped folks, and they kind of arise at every level. Next slide. Okay, so let's talk about the ADA. When somebody walks into your meeting and says, well, I have a right under ADA to do this or that, a park in the front space or something like that, the first thing you need to recognize is this person is uneducated. Homeowners associations are generally private property, and so there is no ADA right. The second thing you need to think about is, so ADA is access, ingress, and egress. But the second thing you need to realize is that they might need an accommodation for their handicap. So when somebody comes in and claims ADA, the first thing is, okay, you haven't taken time really to educate yourself, but what is the problem, sir? Right? What is the problem, miss? Let's learn from it. When we get a call from a handicapped person and they need, access to a pool lift, or they need to park nearer the door, or they need to get a different parking space. Those are the things that we need to listen for to find out if we can make a reasonable accommodation for them to assist them. And so it's not everybody who wants something, it's where they voice a medical need. And it's reasonable, we'll get into what to ask, but it's reasonable to ask for kind of documentation so you can properly understand how these people need help. You can't ask exactly what's wrong with people. We'll get there. But the point is, there is a distinction between ADA and fair housing, but they very quickly bleed into the same thing if they're valid, which is that the person in front of you needs assistance. They're asking for the board to make a reasonable accommodation. And that's what the statute says, that we have to set aside our rules and regulations or our CC&R restrictions to make a reasonable accommodation for somebody. And I know it's not black and white. And the reason that it's not black and white is the legislature wants you to take time to check in with the people and try to determine what is reasonable. And so as your lawyer, what I would do is there's an old adage in this area of the law, which is you never say no, you just continue to offer alternatives which may assist or may help the association meeting the people's needs. So if somebody says, let's go to the next slide. We'll get into that. So let's talk about this. 24 Code of Federal Regulations 100.7 came about because of the Reeves versus Carlsberg condominium case. And it's really a horrific case, and I'll kind of talk about what happened. Basically, there was a African American woman who I don't think you can make this up. I think she worked for the post office or something, And she would leave her house every day and go to work. And uh, the bigot, the guy, lived behind her and used to say such loving and supporting things as, "Well, you're just a fucking and when you get home tonight, maybe I'll rape you," and just kind of all kinds of foul things that made her feel, of course, extremely uncomfortable living in her home. So she went to the association and she said, "Hey, I need out. I need to figure out how if I sell, I have to disclose that the bigot is there. And so I'm going to lose value in my home. I need you guys, the association, to buy out." There was even negotiations by the association to buy her out and give her freedom. And finally, she realized that she could utilize the free services of the courts, and the Department of Fair Housing sued the association, Carrollsburg Condominium Association, and the settlement was, in fact, did turn out, in fact, where the association bought the house. She was at a market rate. She was allowed to leave, and then they resold the house. So the fact is that Reeves versus Carrollsburg went on for 7 to 10 years. And the reason that it went on was Department of Fair Housing sued and realized that they didn't really have a statute on point. In other words, the association said, "Look, we didn't do anything wrong. We didn't do anything, but we didn't do anything wrong. And we shouldn't be responsible for that." And the courts were not really willing to prosecute. So during the pendency of the case, or shortly thereafter, the feds passed 24 CFR 100.7. And this is the language that gets homeowners associations, which are called housing providers, even though we can't control who lives in our communities, and housing providers involved. A person, and the association is a legal person, so the association is directly liable for failing to take prompt action to correct and end discriminatory housing practice by a third party. Okay, that's an owner, the bigot, the person who is misbehaving. Where that person, where the association, where the board of directors was on notice, knew or should have known of the discriminatory conduct and had the power to correct it. When 24 CFR 100.7 came out, all the HOA attorneys got together and said, "Hey, this is completely irrational. This is just crazy, because we can't govern who works and lives in our communities. We might be able to govern who works within it, but we can't control the acts of misbehaving neighbors. And there are communities which are racist to one another, and there's really nothing we can do about it." And the Department of Fair Housing contemplated that for a while, and they said, you can do two things. We think that this kind of behavior is a trespass, and we think that you could probably sue or prosecute based on trespass. The other thing they said, which was much more prescient and what actually works, is they said you could call hearings. Now, the person won't come in or may not come in, but they may come in. And you can hold hearings and you can try to enforce. And that's what I tell my clients to do. Call an immediate hearing. Try to hear what happened. Try to console the person about the wrongdoing. And then, try to talk to the person who did the wrongdoing and kind of explain where it was creating a problem. So this is the protocol, right? And of course, not long, what's that, 7 years? 7 years after Reeves, we got Lawrence. So in Lawrence, an African couple sued Courtyards Owners Association a diverse community of Eastern Indian, African American, Hispanic, and Caucasian descent. And basically, remember, this is federal, so this case is out of Florida, Southern District, Florida. Basically, fair housing came to courtyards and says, the Lawrences are complaining that people are calling them the N-word and telling them to F themselves and all kinds of terrible things. And the association says, yeah, we've held hearings. We brought the Lawrences in and had a hearing, and we were horrified. So we brought in their neighbors, and their neighbors say, yeah, that's what the Lawrences say to us. It's how we talk to each other. We all call each other racial epitaph, and we thought that was part of being in the neighborhood and this kind of stuff. So the federal government said, went to court, and the courtyards won, because they realized that the courtyards had gone through the process, immediate hearing and discussion with neighbors, done everything they really could to resolve the matter. Okay, so this is a great snapshot, this slide, because it really summarizes why the statute came about, the Reeves versus Carrollsburg situation, what the language was that was ultimately determined, and in Lawrence versus Courtyards, what the association can do, even if it doesn't totally resolve the matter. The key is recognizing it up front. I was working with a client. The client received a letter from a gentleman. It's a planned unit development. And gentleman wrote about how he was being name called and harassed, everything else by his neighbor. No word of why we brought him in for a hearing. We said, well, name calling, harassment, this is a hearing. Let's go see what we can figure out. On the way over, I drove past his house, so I knew the address of his home, and I knew the address of the home of the people he was complaining about, his neighbors. And I realized the gentleman had hanging in the back of his house a rainbow flag. Oh, okay. Now I think I know what this is about. Let's go into the hearing and learn. And sure enough, the gentleman was like, "Hey, I don't have any idea why, but these people keep throwing rocks at the back of my house, and they've broken my glass window a couple of times, and they, yell out epitaphs." At which point I said, "What is the nature of those epitaphs?" And I was like, "Oh, FAG and stuff like that." And I'm like, "Yeah, okay, kind of understand what's going on here." In that hearing, you get to hear from the person who was harassed. If you can have a hearing with the other person, you can have a very quiet and substantial conversation with that other person. It goes like this. I'll use the Lawrence versus Courtyard situation. They say, "Hey, Mr. Jones, my name is Mark Guthuse. I'm legal counsel for the association. It's a pleasure to meet you. These allegations have been brought against you. What are your thoughts on those allegations?" Mr. Jones immediately says, "I haven't done anything wrong. I haven't said anything wrong. You can't prove it." Right? There's nothing here, right? To which I respond and I say, "You know what? I'm really happy to hear that. That nothing brings me more joy than to know that this isn't a problem. Because if it is, now that we've talked to you about it, the association's out of the lawsuit loop. You know, if we hadn't done anything, Mrs. Lawrence could have sued the association. But now that we've done something, Mrs. Lawrence lawsuit and if the association gets sued, we're just going to cross complain against you." Now that's going to be prosecuted by the Department of Fair Housing, which is a state-sponsored, unlimited legal fee entity. And when you go to contact your homeowner's insurance to defend you, they're not going to defend you because discrimination, of course, is an intentional act. And so I'm really glad to hear you're not discriminating, because most defendants, when the Fair Housing Department comes through, spend between $50,000 and $150,000 cash with their lawyers defending these actions. And so it's really important to me that it isn't happening, and I'm glad to know that you're not doing it. About 90% of the time, 9 out of 10 times, that stops it. That's the end of it. Having that hearing accomplishes two things. It gives peace to the homeowner who is the victim. And it gives a very clear projection to the bigot, the wrongdoer, as to what the future is going to be. Let's go to the next slide. Okay, so we got to be a little careful. So when we sit down with these people, I want you to bring in legal counsel. If you hear about something like this happening, what do you do? Well, this comes straight out of, you may recognize this if you're an employer. This comes straight out of the Department of Fair Housing and Employment. So if you have an employee who comes to you and says, hey, I'm struggling here because, excuse me, I'm not tall enough to reach the copier, or I need a lower desk, or I need a higher desk, or I want to stand at my desk because my back aches, or I want a ball because my back aches, or I want a different chair. We have to, as employers, say, what are your needs? What do you want? What would you like us to do? How can we make it so that you have full use of your unit and maybe the common area as well? And then, do you have documentation to support that? And this is a little more of the quiet negotiation, right? Because if you have somebody who's towing an oxygen tank in behind them, saying, I need a nearby parking place because I can't walk all the way out to my car, you're not going to ask for documentation. You can see what the problem is. If the person seems absolutely healthy, it's fair to ask for documentation. So we had a situation where a gentleman, let me say one more thing. What you're trying to get to as the board is, what is a reasonable accommodation? And footnote, reasonable is never illegal. All right. If they're asking the association to do something illegal, it's not reasonable. You're laughing right now, I hope. And the answer is, it happens. So we had a gentleman who had his dog, little poodle, toy poodle, and he went everywhere with his dog, including into the pool. And so we prosecuted. We did fines, and then he responded and said, oh, this is a therapy dog. I need this dog as a reasonable accommodation for my emotional well-being. And so I said, you look to me to be very normal and healthy. So, under the law, may I ask, do you have documentation for that pet or prescription? And he said, yes, in fact, I do. And so he went home and came back with the certification that this was an emotional support animal. And at that point, of course, the animal is not a pet. It's now a prescription, right? So I said to him, okay, you're welcome to have the dog with you. You're welcome to have the dog with you in the pool area. But what we can't have is the dog in the pool, because that violates cleanliness laws, that we have to drain our pool each time that a dog gets in it. The gentleman became very indignant because he insisted that his dog was very clean. I said, that's not the point. The point is that health code violations occur and we have to drain the pool. each time you do that. So it's not a reasonable accommodation that the prescription goes in the pool. It is a reasonable accommodation that you can have the prescription as you are sunbathing by the pool. Okay. I just realized the question and answer is different. So let me just maybe take this moment to bring up question and answer because it seems as though I've been ignoring it. Well, before we get to dogs, which is the example I just gave you, what you can't say, like when somebody walks up, you can't say, what's your disability? What you say, or can you prove it? What you say is, what are your needs? How can we help you? That phraseology, even though you're trying to get to the same information, matters. And the Department of Fair Housing will have conversations with you about that. I've had an association that the final settlement to the litigation based on the association's behavior was that each of the board members had to go through 2 days, a weekend of sensitivity, cultural sensitivity training. That was the mediated, arbitrated compromise that was developed when the board was not listening for the person's needs and what they need, and trying to make a determination of whether it was a reasonable resolution for the association. So let's go to the questions. What about number of dogs or sizes of dogs? Right. The Fair Housing Department, if it's a prescription, doesn't care how big the dog is or how many you've got. And I have a number of associations where people have 3 dogs. One is the allowed pet, and one is a handicapped dog for a wife, and another is a handicapped dog for a husband. Is this BS? I don't know. I kind of think so, but I also have a dog that brings me a great deal of joy, so maybe I need it for emotional purposes. I don't know. That's a legislator question, right? So fair housing doesn't care about the size of dogs, and they don't care about the number of dogs. All they care about is that you have a prescription to address your needs, their interior needs. And so it's a very touchy-feely subject. In a neighbor-to-neighbor dispute, one party said the incident happened and the other party didn't. How do you resolve the issue? Shouldn't evidence be provided? So in that situation, again, I listen to the first person, and I'm a human. I can't help but judge and say, really? But always hear it. Remember, I'm also trying to calm them down because if I can calm them down, they're not going to sue my client, right? So I'm going to be very super respectful. I'm going to listen to their allegations of harassment. I'm going to look at the picture on the phone, and then I'm going to have the meeting with the other tenant, and I'm going to sit down. And I'm going to say, this is the allegation that's been made. This is the picture that we were provided. Let's talk about what happened. And then I go into I'm really glad to hear that we're wrong. What matters from the state of California's point of view is that we have this hearing and we listen to you and talk to you. It's not us who's going to make the ultimate decision. If the state of California decides that this is a prosecutable matter, they will. And all we're going to do is cross complain against you because we have sat down with you to discuss the concerns of your neighbor and possible problems. So that's it, man. Get in, get out. We are a 55 plus community. Wonderful. We only allow children in the pool at certain times of the day. Is that a problem? Yeah, probably. I don't know. If it's a 55 community, you might be able to limit them completely from using your amenities. I don't work with many 55-year-old communities. It's something we could certainly research and find out. You should talk to your legal counsel. It's definitely a question mark. If the rules are established as a CC&R, such as no children when you purchase in the HOA, is that a problem? Yeah. So There are certain provisions in CCNRs that are just illegal. I was brought up, I was hired by the Arrowhead Lake Association to enforce their CCNRs on a dock issue. And and so I opened up the CCNRs and I'm reading it, and they don't allow black people or Jewish people to spend the night on the mountain, right? Obviously, this is unenforceable. Obviously, this is offensive. That's the first thing. It just kind of makes you feel sick to your stomach when you see it. But but it's in there, right? And since then, the legislature has created protocols whereby just obviously unenforceable language can be removed from CCNR. So if you do have rules established in CCNR, such as no children or no satellite dishes or whatever it is, the answer is that those rules, if they're unenforceable, then there's no sense in having them. You might as well take them out. And I think having them is discriminatory. If there are numerous two-step, okay, without railing per municipal code entrances into the association. I'm sorry, it just moved. Entrances into the resident buildings and the aggressive behavior. I can't seem to keep this open. It just keeps jumping around. Let's see what it says here. If there are numerous two-step, okay, without railing per municipal code entrances into the resident buildings, and one owner requests a railing on the entrance to her building due to her age and impairment, is the HOA going to be bound to eventually install railings at every no? And no, and since there are other seniors in the HOA, the answer is no. You install it where the person wants it installed, but more importantly, is that owner who pays for the installation. So, so that the owner asks, and the association shall allow when it's an access, ingress, egress improvements. So the example that I gave of the ramp should be a good example on that. Gail C says, so we have a spouse of a homeowner who's been arrested multiple times for damages, vandalism, aggressive behaviors towards our community. She has been in custody for a while and sounds like she may be found not guilty due to mental health issues. This is very common. We call it, we call it storing or where people who are mentally ill get put in a condo association outside of or away from the wealthy parents who just can't take the cacophony anymore as they age. And, the parents explain it away like, oh, she's got her own place now. But the real answer is that the association has suddenly become the caregiver of this person. So the question is, if this is a final court decision, what is the HOA obligation if when she returns? And the answer is, if she says something to somebody, if she says something crummy to somebody and they are offended, you hold an immediate hearing, you hear what that person says, and then you call the spouse of the homeowner in for a hearing and say, hey, this is what we were told. Now, listen, this doesn't always work. This person in your description is kind of a serially mentally ill person, and hurt people hurt people. So, but what you can do is protect your association by documenting having these hearings. For reasonable accommodations, should it be an always or never situation regarding harvest requesting documentation so it doesn't give the appearance of perception that individuals are being singled out? No, I don't think so, because one, nobody else, each offended person, each person who is hurting in some manner, sick or ill or injured or whatever, they don't know what previous people have suffered. And so there is no, I'm sorry, but we're required to ask, what is your diagnosis at all? So do that. Okay, I'm going to answer about two more questions, and I'm going to go back for the hearings, or back to where we were. For reasonable accommodations, back to the pool. If an owner insists the dog be in the pool with him and he has a prescription, can the cost of draining and cleaning be assigned? I think that's reasonable. I think you bring them in for a hearing and say, hey, we just passed our water use. We just put 35,000 gallons back into the water. And according to that, that's a $163 bill. And we'd like you to pay it as damage to the common area. I think it's going to stop it from occurring more. Landscapers spraying pesticides without notice from the HOA. No notice is posted and sent to members. Since homeowners don't want spraying near their townhomes due to medical issues and physician letters to HOA. All right. Homeowners are concerned about their own health and pets. HOA indicates that they don't have to notify members since spraying the common area doesn't have to accommodate members. Comment. Yeah, I think you need to talk to your own attorney. But in the end, depending on what is being sprayed, the association should require the pesticide company to put in proper notices. So proper notices are required to be given by the law, but the pest control companies play a game with the association where they say, hey, the law says the manager needs to give it. And of course, the manager has no idea what these pesticides are. So when you contract with your pesticide company, you need to tell them, hey, if something here needs disclosure or 3 days notice before we spray, you need to tell us what it is, and you need to post the things. You, the pesticide company, have to have that responsibility. Okay. So I'm gonna get out of this screen because I think we could just spend the rest of the day in it. What to ask and what not to ask? What would you like us to do to help you have full use of your home and the community? That's the question to ask. What are you suffering from? You seem very healthy to me. What are you suffering from? Oh, okay. But not, hey, I'm sorry, we didn't understand. Yeah, you're towing an oxygen tank, but we need to understand exactly what's wrong with you. You know what's wrong with that person. All right. So we're not going to go into it. And can you prove it? No, nobody can prove they're mentally ill, right? They just are. Everybody's on the spectrum. Let's go to the next slide. What are the limitations? Well, this is what we said to uh, the state. We said this is an unreasonable law, and that's when they came back and said you can hold hearings. You can, and that turns out to be the answer. You could sue for trespass, and I don't still know how that will be happening as a real estate lawyer, but who knows? In Gittleman versus Woodhaven, they trying to remember the case exactly. But how it played was this. Oh, I remember. Owners were assigned their parking spaces, but some owners, of course, had closer parking spaces to the front door. Gittleman needed a parking space near the front door because he had COPD, what all the things I'm feeling right now, right? Just inability to breathe, inability to operate. Gittleman goes to the association and says, you need to give me a front space. The association comes back and says, all those spaces are deeded. If that weren't the case, if they weren't deeded, the association does need to give Gittleman a front row. If the association controls the parking, the association needs to give Gittleman, the handicapped person, a front row space. But in this case, they couldn't because all those spaces were deeded, right? Okay, so we had assigned spaces. So now what? The court came back, California, okay, and this is part of the, or I'm sorry, this is New Jersey, so also very, very liberal. But part of the problem with this, the court looked into the CC&Rs and said, there's a provision in the CC&Rs, administrative, which says that owners can exchange or trade exclusive use parking spaces. There's a process in the CC&Rs. You, the association, should have held a hearing where you invited people who had spaces near the front of the building and gave them the opportunity to trade spaces. It's up to them, but the association should have administrated that opportunity. Okay, so now we're seeing that line started to be created. The statute says that the association must allow handicapped people with a handicap, to improve their path of travel from their unit and back at their own expense. The association doesn't have to come out of pocket in order to make these improvements. Okay? Have held a hearing, you didn't. So you didn't do everything you could do to help this guy. So I hope that helps you understand. It says my connection is bad, but let's go to the
You
next
dropped
slide.
for about a second there, Mark.
Okay.
You just want to
So
do that last sentence over again.
the court said you could have done something. And so they ruled against the association. But the real takeaway is the owner has to pay for the improvements, but the association has to pay for all the administration, every possible administration. Next slide. Putting it all together. When somebody comes in and says, I have a problem to the association, you need to open up immediately an immediate dialogue. And I'll give you a case that I've changed the name to protect the innocent. So Peel Place was a high-rise association, and the owner in the unit, Mrs. Bumble, was a past cancer survivor. And we had 100-mile-an-hour winds, and the winds, the volume of wind blew water up through the drainage holes in the windows and into the unit, because we had 100-mile-an-hour winds, and they were these 4-story buildings with no protection. So when she wrote an immediate, I mean, it was the day of the storm. She wrote a 6-page letter that basically said, listen, I'm a cancer survivor. I have a problem. I don't want to have mold. I have an extremely limited respiratory, and you're making me sick, and you've got to come address that. And so we held an immediate hearing. And we sat down with her and said, what do you want? And she said, I want somebody to come in and seal the windows. I want all the windows replaced. I want all the windows replaced on the 4th floor, a high-rise building. And she said, it was all glass, pretty. And she said, I need any mold taken out of my unit. So great. We said, great. Tomorrow we will have a cleanup company come out, and they will remove anything that's wet, and we'll dry it out, and then we'll take a look at the windows. And so we did. She did not allow the repair people in the unit. She refused us access. And so we wrote her another letter, and we said, let's have another hearing. You denied access to the cleanup group. She said, listen, I was afraid that if you opened it up, it was going to kind of metastasize mold throughout the unit. We said, no, we have, these are professional cleanup crews. They'll make plastic rooms with fans that take it out. We know what we're doing here. And didn't let us in. But kept insisting the windows get replaced. And we called the window manufacturer, and shockingly, the window manufacturer said nothing's wrong. So we then went to a fenestration expert. A fenestration expert is a window expert who isn't hired by the window company. And he actually explained, yeah, the windows are performing exactly like they should. They're just, if you have 100-mile-an-hour winds, it's going to blow rain up through the drain plug, and you're going to get it inside. We just don't have many 100-mile-an-hour wind days. And so she brought an action. She got an attorney. They negotiated. We're like, hey, we just want to get in and clean. All the time, I'm writing her a letter every quarter that we stand ready to enter, and we want to make it right. But we're not going to replace the glass after we talk to the fenestration expert. So it's just a seasonal thing. If every time we have 100-mile-an-hour winds, we'll come up and do this again. So she finally figures out that she can make a claim on the internet. Fair housing descends on us, and I produce 12 letters that basically are, hey, it was a pleasure meeting you. We'd like to come in, and hey, you didn't let us in. Hey, we stand ready to come in anytime you want. And so we went through the process with fair housing, and that was about I don't know, 15, 20,000 bucks. And finally, fair housing came to us and made an offer. We'd like to make an offer to you. So, okay, what's the offer? Well, we'd like to give you the opportunity to pay Mrs. Bumble's legal fees, if which were, I think, $70,000 by that time. We charge less to defend than they charge to plaintiff. And then if you do that, we will not have to make a decision whether the Department of Fair Housing is going to prosecute. And I went back to the Department of Fair Housing and I said, well, wait a minute, if we've done something wrong, we should be prosecuted. This kind of feels like a shakedown. Client said, look, we're not going to pay anything. Next day, Fair Housing calls us and says, we're going to dismiss the complaint. I said, would you be kind enough to let me put you on speaker with the attorneys from my firm, because we want to pepper you with questions, how we can do better at this. And they were kind enough to go online with us. And basically they came back and said, look, you held an immediate hearing. You dialogued with the person all the way through. You offered to make the repairs. You documented your offer to make repairs on a quarterly basis with a cheap letter, man. And we think you've done everything you can. We think you acted in a model manner. Great. So that hung up, said thanks, patted ourselves on the back. You can do this too. When somebody feels mistreated, open immediate dialogue. Try to find out who, what, where, why behavior. Listen to what they're saying. Document their requests and responses. Communicate genuine compassion. Be creative in possible solutions. So this comes up, be creative, because here's what happens, right? Association doesn't allow upper story units to put in hardwood floor because of the noise, right? Tapping of people walking across the unit. Person puts in wood floor, they get a violation letter, and they immediately come back and say, well, we needed to go to the wood floor because we have allergies. And the answer is, well, there's other solutions besides a wood floor. There are wood floors on an inch of cork. There are wood floors, or there are vinyl floors that look like wood but don't tap, tap, tap like wood. There are linoleums that look like wood. There are, so really the answer is the association should look for creative ways to try to resolve the issue. Let's go to the next slide. Okay, Geraci. What you need to understand is when a person makes a fair housing claim, they have a right of privacy as to their claim. We can't tell people how these people are suffering. We can't tell people what was done wrong. It has to be done in a hearing where there's privacy. In Geraci, the owner sued, and the association had a meeting where they discussed the lawsuit and what they were going to do in terms of defending it. Geraci sued. Geraci sued the association at that point. And so initial claim against wrongdoing against certain board members, now sue the entire association because you've made public what my personal emotional issues are. The association defends and the court finds, look, the association notified the members of your claims, which you made through a legal lawsuit. So you've disclosed those things. You don't have a right to privacy as to the things you've disclosed. The association has every right to try to talk about them and find ways to resolve them. So by virtue of you suing public forum, you've waived your disclosure privacy rights. Okay, why am I telling you this? Well, because this isn't the only person who will want an accommodation. And you've got to foresee this when you make an accommodation. So we cannot disclose that the reason that Mark got a front row parking space is because Mark has a handicap. Okay. Unless we get Mark's permission. And so as the attorney for an association, what I say to people, so here's the example. We have an association, it's a high rise. The person is the fair housing claimant is a veteran. He got permission to put a jacuzzi on his deck. The buildings aren't really engineered for it, but the engineer said, look, one jacuzzi, fine. We just can't have jacuzzis on all the decks. It's just not engineered for that kind of water weight. We go back and tell the veteran, you can have that. But you have to allow us to disclose why you have it. That's the reasonable accommodation. So that when we get sued by a not veteran handicapped person for not allowing a jacuzzi, selective enforcement, we can say publicly to those people, the reason that we did that was because he is a handicapped veteran who had a note from the Veterans Administration, right? So when you're making high profile accommodations, make part of the written agreement, yes, written agreement, that, hey, if somebody sues the association or somebody ADRs the association about this, that we could disclose your situation. We're not gonna send it out in Christmas cards, but if somebody sues the association because they can't get a jacuzzi, a spa, a hot tub, it's not a trade name. But what I'm saying is, you get it. All right. So boards can inform members of litigation, of details disclosed in litigation. That's fine under Geraci. But other than that, you need to understand that these people have privacy rights, and we can't tell others why they're getting these reasonable accommodations unless we get an agreement from them that we can disclose that. Next slide. Connor.
I'm here.
Oh, well, that's good. All
We're
right,
heading
so
off
let's go back to
into
the Q&A.
exactly. And just real quickly, Mark, I do want to say thank you for our Q&A sponsorship from CID Consortium. And we're going to go ahead and head back into the questions.
All right, so are all requests for railings or banister modifications that are approved by the HOA paid for by the owner, not the HOA. If they are requested by the owner for as an accommodation for their handicap, then they pay for it. That's the statute. I'm looking at railings, and railings can be a little tricky, right? Because there's a lot of railings that are out of code. And so I imagine that if, they're supposed to be down to what, 4 inches? You can't get anything bigger than 4 inches between them. So I imagine if I had an out of code railing, I might be inclined for the association to pay for it. If you have a married couple where one person has a mental illness and the other person has an alcohol disorder, oh, perfect. What is the HOA responsibility? They make a lot of noise. He spills drinks in the lobby and elevator. Can they be charged for cleaning? Yeah, sure. That's not a handicap, right? So yeah, if somebody damages the common area, you can hold a hearing and say, look, we have to pay somebody to come in and clean up after you. That's just damage to the common area. We have had multiple hearings and fines before her current incarceration. Okay. Thanks for the insights. You're welcome. Follow-up question. Are you saying that an owner requests a railing is to pay for the installation of the railing and not the HOA? In the latter, then other seniors will request, right? So you're talking about like a railing to get up their stair. Okay, I get that. No, that's theirs. If somebody wants to, what you're doing is approving what the architectural improvement is. We'll allow you to install it. The statute even says that you can require them to remove it. I've never gone that far. I think that's a bad move. Regarding required to remove it after they no longer need it. So we had one situation where we did plug that in. We had an owner who lived upstairs and she got one of those nifty butt buckets, one of those nifty things that goes up the stairs, riding on a rail on the side. And we did say, we approved it as part of their architectural improvement, but we did say at the point that you no longer live within the unit, that needs to be removed. So we do that. Oh, pesticides, herbicide, I don't know. Just talk to whoever's doing your spraying. That's who's legally required. Look, they show up with bottles of stuff and start spraying. It's important that we know what they're spraying. But in the old days, they used to spray all kinds of stuff. And then these disclosure laws came through, and suddenly they're spraying with completely different things that don't need to be disclosed. So the difference between a herbicide and a pesticide, God help you, I don't know. How do hearings fit in the legal procedure, IDRs and ADRs? It's like an IDR. We're just, I will always hear the complainant right away. I will always hear the complainant as soon as they're willing to meet. Somebody makes that complaint, it hits my desk. I call the board president. I say, when are you and maybe a couple other board members available? I try to meet with them as soon as we can. I'm trying to head off a lawsuit at that point. And then as to the bigot, the bad guy, that I give 10 days notice. So every hearing is held at 10:15. I teach my managers to do this. Every hearing is held at 10:15. So California Corporations Code says that if we're going to give a hearing, we need to give 10 days notice of the hearing. We need to have minutes of what occurs at the hearing. And then we need to tell people within 15 days after the hearing what the penalty was. Okay. So there we go. The hearings fit into the IDR, ADR procedure like that. Does the owner have to attend the meeting? No, we can work with the tenant. If the tenant is the injured or damaged party, we can work with the tenant. I've never heard of a hearing called for anyone at our HOA. Okay, well, can we bound charcoal lighter fluid? What does this have to do with handicapped people? It goes into neighbors' windows, nauseous and dangerous to breath. Okay. Our units are in close proximity. Yeah, you could probably damage charcoal fluid. And while you're at it, you could probably get your fire insurance, your property insurance to give you a mandate that you get rid of charcoal fluid. Those guys don't like gas barbecues, let alone, but they hate charcoal fires. If board members tell a new owner, no issues here, no noise, and a new owner moves in. Okay, so the board lies to a new owner, moves in, and neighbors are disruptive. Can you bring an action against the board member or members? Sure. Also, the seller and real estate agent accountable for not disclosing this. Yeah, absolutely. That's an issue because one, your board members should never be talking to buyers. That's crazy. But we do have situations where, like, I have a situation where we have a handicapped kid, and he makes all kinds of noises, and he's a big kid. He runs and jumps. I think mentally he's maybe 3 or 4, but physically he's 20, and he's a lot. And the lady who lives underneath him is just at wit's end because, he screams in the middle of the night and that kind of stuff and runs up and down. And she's like, I can't sell it because I have to disclose it. And as soon as I disclose it to anybody, they don't want to buy the unit. And I can't sue them because under the fair housing, I'm just going to get sued for harassment. I'm like, yeah, you're in a tough spot. So, yeah, board members shouldn't be telling people things are quiet. I don't know why they would ever do that. Define administration. Do you mean legal fees or do you mean construction administration? I really don't know. We're talking about the Fair Housing Administration. The Fair Housing Administration is a department of the state of California, and there's also a federal Fair Housing Administration. So that might be what I was talking about. We live in a large gated neighborhood of townhomes. Good. There have been an increasing number of situations where children are riding their bikes through the community landscape area, damaging plants, climbing on fences. The destruction is also a safety issue if their bike catches a plant and they're injured. We're working on getting additional fencing, but that's going to take time. In the meantime, warnings and reminders are sent community wide. You got to be really careful about that. You can't be talking about these words: children, riding bikes, play, all of those. Be very careful on those notices. Our HOA manager said that the communication cannot specifically identify children or minors. You have a good manager, because that would fall under discrimination. That we have to use blanket term residents. This is true. Most people don't usually hear the word resident and think of children. Yeah. Is there an issue with reminding residents and their children should not be doing things, or does it have to be a generic residence or not? No, your manager is correct. Oh, what's next? What about 326 and about deck? What about them? We could talk about that all day. Thanks, Connor. Are your answers just for disabled person, or do they apply to complaints brought to the board? Louise, I feel like I missed something in your connection. I'm trying to explain how a board should handle complaints that are brought to them from disabled people. And so 217. So if I didn't communicate that clearly, I failed. So let's see what else we got. Okay, we got a lot of Happy and O'Connor, but there don't seem to be many questions. Okay, here we go. I'm in the webinar chat now. Resident complained to the county about pesticide use and notification. County met with management. County official recognized landscaping company knew their compliance in using chemicals properly. Stated the chemicals being used only needed signage only during application. However, we notify of schedule and post during use as an accommodation. That's a great thing. Nothing wrong with that. So, what I envision is, hey, we're going to spray water and vinegar on next Thursday, whatever it is, and that's disclosed to the members. So you can't lose. That's great. You can lose because people will complain, but it's the right thing to do. Last slide, we'll head back to Q&A. Glad you can make it. Oh, good. I hope it was helpful to you guys. Well, I think that's about it, and it's been a privilege being here. I'm a huge fan of Echo because I just feel like the void between Democrats and Republicans is growing so broad. The void between people who understand how a homeowners association is supposed to work, volunteers leading a volunteer organization. The more educated that we can do, the more education that we can bring you guys, the better that you're able to pass through to people who just don't get it. And you're going to make your communities a lot better. And that's why I volunteer and donate my time to Echo. And I'm a big fan of Echo, and I'm a big fan of Connor's Pony. So thank you very much.
Well, thank you very much, Mark. We're going to go ahead and do our closing here. And so we'll just be a couple more minutes for everybody. But I do want to say thank you to all the Echo members for coming today and supporting our ongoing Echo webinars. For those of you who are not Echo members, please consider becoming a member and supporting HOA boards throughout the country. To join, simply go to www.echo-ca.org and you can register for whatever membership you like on the membership tab. For Echo members, thank you for supporting us, and please invite your friends, boards, and especially your management firms and vendors to join Echo. A simple invitation is often all it takes to encourage someone to join. If you would like to be more involved with us and maybe volunteer a little bit of your time, you can be a member of our Volunteers Corps, and this is a great opportunity. If you want to take a look at the screen, these are some things that we currently have open for volunteer. And if you're interested in any of these, please contact Dave. His email is at the bottom of the slide. Now I'm going to go over some additional announcements. The Echo HOA University is an educational program focused on HOA board member preparedness. The core curriculum of 10 courses is designed for high quality training and is available for HOA board members, interested homeowners, and professionals. Your participation in this program will earn you a certificate of successful completion. The courses are initially offered live online, but can be taken at any time via the recording and then taking the test. If you or someone you know wants to sign up for this program, you can send me an email or you can reply to your invitation to this webinar and I will reply to you back. Registration is also available on our website if that's something that interests you. We're going to be going over just a little bit about the resource panels we have coming up. We just ended our Q2 resource panels. Our third quarter resource panels will be happening at the end of summer. Starting off with our Sacramento resource panel on Tuesday, August 5th, followed by the T-Car panel or the Echo Club at Rossmore on August 6th, and then our East Bay resource panel on August 7th. We're currently deciding the finalizing the topics for these resource panels, but they'll be available on our website and you'll hear about them as soon as we have them set in stone. For those of you who are in SoCal, we have our SoCal resource panels happening at the end of summer as well. We have the Los Angeles resource panel on August 12th. We have the Orange County resource panel on August 13th. And then we have the San Diego resource panel on August 14th. We are also doing 3 larger events this year. These are our educational seminars. These are larger in-person events with actual vendors there on site for you to talk to and for a lot of interesting presentations. Our upcoming one is the June 7th event in Northern California. This is in San Jose at the Villages Golf and Country Club. It's a great webinar, or it's a great in-person event, especially with all the great information that we provide. We have over 20 vendors that will be there as well if you're interested in looking for additional vendors. Registration for this event is live on our website right now. You can register. If you register early, you can even get a free registration. So make sure you take advantage of that and register as soon as you can if you think you can make it to San Jose. And then if not, we'll be sending out a web brochure after today's webinar that will also invite you to register as well. I do want to say one reminder here before we talk about the webinars. This presentation was recorded and a copy of the PowerPoint was sent to all registered attendees. So if you didn't get that, you feel free to email me and I can send you the PowerPoint. If not, the community conversation will be up on our YouTube channel within 7 to 10 days. If you like webinars and you want to know some more webinars that we're doing coming up, on May 17th, we'll be doing our Ask the Attorney about laws other than the Davis-Sterling Act. This is where we go in and out of other laws that affect HOAs that aren't encapsulated in the Davis-Sterling Act. On June 4th, we'll be doing our Ask the Experts about insurance. We have 4 insurance brokers that are going to be doing presentations on the state of the insurance industry and the state of insurance in California. So if you have had issues with insurance this year, or if you're still having issues finding insurance, this might be a great webinar for you to go to. We'll also be featuring breakout rooms during that, where you can go into the rooms of the brokers that are participating and ask them questions directly. On June 14th, we'll be doing our educational workshop on good governance and leadership. It's a great webinar. It's part of the HOA University, so if you sign up for that, you'll be automatically enrolled in that as well. We go kind of into how do you actually run a board? How do you be a leader in your community? It's a great presentation, especially for newer board members who are just learning how to interact with the community on a board level. It's a great webinar for them. And then on June 14th, we will be doing our community conversation on tree care in defensible space. This is talking about trees, talking about how to trim your trees if you're trying to be fire wise and keep your community fire safe as well. It's a great presentation, and if you want to be at that one, that'll be happening on June 14th. We also have the Echo Board Members Club. This is happening next Tuesday on May 13th. The Board Members Club is a group that meets every second Tuesday of the month from 5:30 to 7, where the board members get to talk candidly with one another about issues that are relating to HOAs. You get to hear feedback from other other HOA board members or former board members and see what they've done in their association, and maybe you can take some of that experience back to your own. The BMC registration, you can ask me for the link. You can either send me an email or put it in the chat of here of the meeting for today, and I can send you how to register. If you are a member of Echo, if you log into your profile on our website, the link is also there as well. I do want to say thank you all for being here. Mark already took off. He wasn't feeling very well today, but thank you for Mark for doing this event. And of course, I want to say thank you to all of you once again for participating today. Echo appreciates your investment in education to foster a better quality of life in HOA communities.